Good morning, everyone. I'm not seeing a picture. There we go. Somebody saying they had nightmares last night? Hi, fan lady. How many of you think that we're going to be done by Friday? Anyone? My cat likes true crime. Good morning to you. Good morning, Stephen. Here's my prediction. Sarah is going to get on the stand today and lie her face off. She is going to try to incorporate as much as she can, as many lies as she can, from the power and control wheel. And she has to come up with an overt act that Mr. Torres did that will allow battered spouse, even if it is an outrageous lie, because even if it's a lie, then battered spouse is allowed in as evidence, as an argument, and then it'll be up to the jury. I think that's what's going to happen. Stephen says she won't answer a single direct question from the prosecutor. Matilda says she thinks it will end early next week. Yeah, the prosecution's rebuttal will take days. Good morning, New Brunswick. I've been there. It's a beautiful place. Good morning, Gregory. Pesky citizen, good morning. Oh, JSS is glad for the timestamps. I'm glad they're useful for people. Cecilia says, I think the state's rebuttal will take longer than her case in chief. Wiley Coyote Super Genius says no way she gets off on battered spouse. Do you think that from the point of view of someone who has not heard of this case, who doesn't know anything about it, what do you think the jury's thinking? Because we have all kinds of information that the jury never saw or heard. Good morning, Brazil. Buffy's asking, do I understand Sarah deleted the videos? Phone specialist said second extraction was needed. So the phone, the digital forensics, I think we're starting to download it at the scene. And once they realized that those videos were there, Chelsea said, hey, stop. Let's actually get a search warrant. They didn't need a search warrant because they had her consent, but it's better. I thought that was a good move because it's better for the detective to say, okay, we're going to get a warrant, because if she later says she didn't consent or it was under duress or something could go wrong with that. So let's just get the warrant, which they did. So they stopped. And as far as the videos being deleted, I don't think so. I think if they were, the prosecution would have highlighted that. LalaTube says every single person I talk to knows nothing about the case. Interesting. It's all very interesting to me to see how people perceive this if they've never seen the case. Oh, so we have a court seal already. I'm going to to change this. Okay. Cat Lady says, I think the suitcase video and interrogation are unforgettable, and the jury won't be able to get over those. Matilda says, I heard there was a jury member in tears after watching the video. I don't know how you cannot be horrified by that, at least. And it's just amazing that Sarah didn't cry. This is something she was responsible for. Nikki says, I can't see how the jury cannot see or hear that video, then see the 2-hour interview and how angry she was and the fake emotion stuff. Stephanie, yes, they did show the suitcase video to the jury. Al Lozerath says, yesterday was incredibly powerful. The state did a great job of timing and presenting in the order they did. I think so too. Good morning, Nancy. Oh, from Orange County, Southern California. Yes, so today I should let you know, I know already she's going to irritate the crap out of me. I know this. I know I'm going to get mad because she's going to be ridiculous. So I'm probably going to interrupt a lot. But I think you can, I don't know, the word is not commiserate, but I think that we're probably all on the same page anyway. Good morning, Jane. Pesky Citizen says, explaining it to my mother, she's in shock. Yeah. Jackie, well, you're going to be mad and irritated right along with me, right? We're all going to have to go watch a comedy or something after. Good morning, Silverberry. You're still famous today. Oh, Jay-Z, you have to work today. Rosie says Sarah's going to annoy the heck out of everybody. Yeah. She can't help it. AKA the cat lady says that with my background, she's interested in my take. I mean, I already have a take, right? Having seen all her behaviors, I think that anyone in a relationship with her is at risk of harm. Rel says, your irritation is safe with us. But first, we are going to hear the direct and cross examination of Chelsea. So that's going to be interesting, what that cross is going to be. Ms. LT says, hello all. I know my patients will be tested today. Deep breaths, everyone. You know what I have? I put this on my computer and I might forget to use it, but check this out. Pants on fire. Good morning, Carla. Jojo says Brian was so lucky to get out. Yeah. GB says, hello, everyone. I heard last night all her lawyers went to jail to coach her. Man. Wow. Lalatube says, you know she's been rehearsing. Yeah, that's something. Good afternoon, Denmark. HRH mom, is there a way that her letters to the judge can come in where she talks about knowing more than lawyers? Um, there's no need to rebut whether she's smart or not. So that aspect of it, no. There is maybe if she said unintentional in her letters, there's a possibility, but I doubt that the prosecution is going to drag things out. I think they're trying to be pretty concise. Giovanna says, I think Sarah knows it's not going her way. Really? How many of you think that? Or how many of you think that she thinks things are going well and she's going to prevail? Who's that lady in the checkered dress? She looks really frustrated. Froki says, I'm glad to be a sociopath. They won't be annoyed. Ms. LT, is there any coaching, Sarah? After all, she excels at everything. I think you could coach her if you showed her how a thing was in her best interest. Good morning, Gettysburg. Frauke says, I think her lawyers told her that it looks bad for her, but I don't think she believes that. I think she is so intent on, everybody adopting her worldview that it's a struggle for her to see anything else. Lee says, I think she's confident in her innocence. I know somebody who is a narcissist who is, I can't, there's a circumstance I can't sort of avoid it. Family, right? And another person in that circle said, that person cannot ever see the truth fully because it would be too destructive for them. So I think deep down they know on some level, but they can't handle seeing it fully. I think Sarah can't handle accepting the truth because it goes against everything that she wants to believe about herself. That's what I think. Ingrid says Sarah's not a good actress. Hi, Sweden. Hi, UK. HRH mom says, I think that when things don't go well for her, it's the fault of her lawyers, the legal system, the judge. Yeah. And soon it will be the jury's fault. Yes, I agree. She cannot take responsibility. Yeah, she can't. Elle, Elle says she can't handle the truth, like that movie. Oregon Coast says hello. Hello back. Can she have been schooled in body language or watched videos that show what fake emotion looks like? I think if somebody tried, it still wouldn't, I don't think it would work. Even people who know about these things, who try to fake it, they can't. AKA The cat lady says, I know I'm going to be furious if Sarah says George abused the dogs when she was saying how much he loves the dogs in the interrogation. I wondered yesterday when that came up if when she heard that, she realized that maybe she should modify whatever story she was planning on telling. GB's asking, do you think she'll say a totally new story today? Yep, I do. I can see chat, Mace. Thank you. Froggy says, and all of her lawyers have to know she won't heed their coaching. They would coach anyway. And when you coach a witness, you're not supposed to tell them what to say. You I stay far, far away from that so that there isn't even a question. One of the things that you can be asked as a witness is, did you discuss your testimony with anybody? So if you say yes, then they can dig into that a little bit. Jay Roberts said Sarah was listening to every word everyone said. Yes, she will modify her explanation of what she did. Yeah, I agree. This is her pattern. This is how she is. I'm noticing, by the way, I'm looking at the court here, the defendant is not in her seat. So, is she not there yet? HRH. Oh, sorry. You're talking to somebody else in the chat. Froki says, yes, Sarah will try to imitate normal people behavior. Yeah, she will. But she won't get it quite right. So for us, the timing of when we show empathy is natural. It's not something that we think about. And showing empathy at all isn't something that we think about. It comes onto our faces, it comes out in our body language, even if we're not thinking, oh, gee, I should display this. For somebody like Sarah, that's tough. She has to try and figure out what the timing is. And that's where you notice things in people like that. Their timing is a little bit off. Nikki says the law students around Kranick are reducing day by day. Yeah, who knows? Maybe they have other assignments. Blink Bunny says she cannot show remorse because she thinks she was superior to George and he was beneath her. That's certainly the attitude, right? Here we go. Here she is. Rel says Sarah cannot think fast enough on her feet. Yeah, she does play dumb. And I don't know that it's that she doesn't know the answer. I think she's either sometimes recalibrating a lie and sometimes trying to figure out, how, I don't know, I'm not sure what to say, or I want to sort of slice it down the middle. I don't want to answer. I don't like the implications, so I'm going to play dumb. Catherine says Sarah is in for a rude awakening today. I wonder. Jane says yesterday she was a snake, today the Black Widow. Yeah. Somebody's saying she can't show remorse because narcissists are never wrong. Yeah. Amanda says, I hope George's family is able to make victim impact statements. Yeah. And remind Sarah that she's not the victim here. Although Sarah, I think, forever will believe that she is the victim. KPM's asking if Sarah will do a narrative today. I don't know. The state thinks that it should be in narrative form, but it is the decision of her defense team. And they can say, because they can't suborn perjury, but they can say, we believed her that she was telling the truth. BGM has donated to Watson for sticks. Thank you. Watson will be very happy with that. Christine says, I'm a little afraid of today. Hopefully it won't be drama. I think it is going to be a drama. And I was telling everybody that I'm probably going to interrupt a lot. And we can just all be irritated and outraged and, mind blown together. Rosaline, no, nothing has happened yet. We're just yapping. Thank you, Romeo Saints. Somebody asked who on her team is going to be questioning her today. I don't know. Oh, KPM is saying someone in the courtroom yesterday said Mr. Henderson looked shocked when he saw the interrogation video and didn't look happy. Interesting. And that's the other thing. I mean, all three of these lawyers, I can't imagine all three of them had time to look at every single piece of evidence. Your colleague might say to you, give you sort of a synopsis of what something was. So that's interesting. Ray B is asking, is Mr. Henderson the man to her right? Yes. The detective was not cross-examined yet. Somebody was asking that question. Christine, I can't bear it without you guys.
Case number 2020 CF 260, this is State of Florida versus Sarah Boone. Pronounce your names for the record, beginning with the state.
Dave Ketchner on behalf of the state. William J. for the state.
Defense.
James Owens for Sarah Boone.
Tony Henderson for Sarah Boone.
Ms. Boone, raise your right hand to be sworn, please. Do you swear or affirm that the testimony you give shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
Ma'am, good morning. Can you state your full name and date of birth for the record for us?
Sarah Boone, 10-10-7-7.
All right, Ms. Boone is seated at counsel's table wearing a black blazer and a dark blue blouse. She is in custody. However, she is not in any restraints, so we will continue to stand while the jury panel enters and exits. My understanding is that our panel is here this morning. State, do we have any housekeeping matters we need to address before we bring back in our panel?
Yes, sir. 3 discovery issues, and then I filed a motion late last night requesting an in-camera inquiry into a potential conflict of interest. I copied your JA.
I did review the motion.
Okay. The 3 discovery issues are these. One, on October 5th or October 4th, I believe.
So did you all catch that? A potential conflict of interest. But they're going to do that in camera. I want to know what it is.
Defense was provided with the body-worn camera 911 calls from the prior incidents, and there was a request made to tell us what, if anything, should be redacted from their point of view so that we could either reach an agreement or use the court's resources to decide any conflicts in those issues. Yesterday morning was the first actual response I got from the defense team, and it was incomplete. It was about 3 of the 5 incidents. I do agree with 2 of the redactions, and we're getting those taken care of. But obviously, just like connecting to the court screen, it takes time, and I'm not the person that's going to be doing it. Somebody else in the office has to do it. The third incident, I think we're still not on the same page as to what the state's planning on introduce. So I resent the email with the screenshots of what files the state plans on introducing to the defense team again this morning. I have not heard anything yet from the defense team about the fourth and fifth incident. I was told that Attorney Beck was going to handle it. It is now Tuesday, day 7 of trial, and he has not handled it.
Okay, I'm seeing people in the chat saying they don't understand. So, what's going on? Remember the prior body cams from the prior incidents where Sarah called police? Defense and prosecution can both use those if the defense wants to bring up past actions of Mr. Torres, if they can get in battered spouse defense. And the defense, though, is going to want certain portions of those body cam videos redacted. And the prosecution said to the defense, hey, what parts, you need to tell us what parts you want redacted. We need to talk about it. We need to agree upon it. And then somebody has to actually go in and do the work of redacting those things. So that stuff takes time. Well, the defense didn't bother really responding at all until yesterday. I mean, we're a good way through the trial, right? The prosecution is almost ready to rest, and they're talking about this now. Okay. So once again, Mr. Owens is pushing that envelope. I mean, last minute Owens here, and they still haven't agreed on some other stuff. So did that answer your question? I hope. If it didn't answer, Tiffany says he'll blame FedEx. If it didn't answer your question, let me know. Okay?
Second discovery issue is Friday I was given a hard copy of the 119 pages of the second copy of the Winter Park Advent Health records.
On 10/18, October 18th, that would have been the preceding Friday.
I was given the hard copy after court at about 5:30, 5:45. I emailed the PDF of those records back to the defense as they requested. I put Bates numbers on them. I understand from court what pages they indicated that they want to use and what pages the court indicated should be included at the state's request, which is pages 26 and 48 out of the 111. I would just appreciate if I could get a copy of the intended exhibit as it shall be introduced into court so I can confirm those things ahead of time and not in court. And then the third thing is, I believe we had a discussion about the plethora of pages regarding the victims' hospital records, and that there was some sort of discussion we had that they were to narrow it down. And I have not been given any narrowed down version of that so that we can confirm we're on the same page or use the court's time if there's a conflict. Thank you.
So Owens was supposed to give these records, this narrowed down version of records. What was it, a week ago? It was, I think, was it even before jury selection or just at the beginning? So Owens just doesn't do anything. So he puts the prosecution in a terrible position. And I think that is intentional. This is irritating. I'd be really ticked off if I were Mr. J.
Okay. Responses to the first discovery issue regarding body-worn camera and 911 calls is to the, my understanding, 5 prior incidents. Defense.
Judge, I can speak to 3 of them. There were 3 of them that I reviewed, and I believe I reviewed them on Sunday. I had made the decision for what I thought needed to be redacted. I think the first 2, if I remember correctly, I said that was fine. We didn't even have any redactions to it. I think it's one that I said redactions to, and I think the state agrees with that. The specific one that I didn't quite know And I think that has to do with a body cam where it comes to, and I believe it's Mr. Torres's mother. I can't quite be for sure, but she's been asking questions and all, and I think it's about, if I can recall correctly, about Mr. Torres's whereabouts at that time. I didn't know the relevance of that at that time, but that was the only part of that to let the state know. I just don't really know the relevance. It could come in at a different point and become relevant. But as to the other two,
Ew. Okay. So Henderson, you remember that body cam video when the police went to look for George, went to George's parents' house because that's where he was staying, and they end up speaking to Mr. Torres's mother. And she is lovely. She is just this sweet senior woman who was very forthright with police, not the scary, evil monster that Sarah wants everybody to believe that Mr. Torres's family is, right? Very sweet. I could see the defense not wanting that in. And so Henderson is saying here, I'm not sure if that's relevant, except it is. So very interesting to see if the prosecution will be forced to cut that out.
I think we were on page with. I had been out to the jail that day. It was late. Then I asked Mr. Beck to do the other two redactions, but I hadn't had the opportunity to talk to him about that since, so that's where we are.
So is the third incident that the state has identified for which there's seemingly no responses to redaction, is that the body-worn camera purportedly between law enforcement and Mr. Torres's mother?
That's what I believe it to be.
Mr. J? Bless you.
We're just not on the same page. On that third incident, which I believe was June 15th of 2019, the state only indicated to them that we were intending to introduce one video file. It is not of the victim's mother. It is of them at Sarah Boone's house. And the objection to the files that they were objecting to, which we don't seek to introduce, just said ID, and I don't know that as a legally recognized objection. So I'm confused. I'm not sure. I'm just trying to make sure we're all on the same page. We understand which file the state wants to use regarding that third incident, because he's describing files the state does not intend to use. The first couple of incidents, we agree. There's a 911 call that seemingly cuts off into an OPD call at 3 minutes and 51 seconds. We're cutting that to the end. The second one, Ms. Boone at like 3 minutes and 43 seconds indicates that she had been arrested prior. So we cut that out at there. We're going to cut that out at there. That cat's out of the bag. So what we're looking for now is just making sure we're all on the same page about the third incident. I sent screenshots. There's a tool called Snipping Tool in Windows. I literally create a rectangle around the files that I'm intending to use, their file size, and the folder that includes the OCSO agency case number incident, so we could be as crystal clear as possible. And I'm still getting objections about things we don't want to introduce on that incident, and I've gotten no response with the fourth and fifth incidents.
All right, addressing the third incident is the specific portions of the June 15, 2019 incident, seemingly the body-worn camera that you're making reference to, Mr. Henderson, the state has no intention of utilizing.
Yes, sir. And Judge, it's a lot, so if I could have one more
Sure.
to isolate which incident it is.
So the video of Mr. Torres's mother will not come in. Somebody was asking in the chat if Chelsea was demoted, and the answer is no. Going to cold case,
My understanding is
sorry, going to cold case is not a demotion. You're still in homicide. That's not a demotion. In fact, one could argue that you need a certain skill set to be able to do cold case.
The state is talking about the third incident. That would be June 18th.
Here's the problem. I sent these pictures over with the OCSO case number, and then I get a response based on incident dates. So we have to kind of cross-reference. So you can just make the record entirely clear. OCSO incident 18-067501. There was no 911 calls and apparently no objection. So they have no redactions requested for that 2018 case. Then the next response was 6/15/2019 case. And that, for the record, is OCSO 19-054917. Their request on that one was the 911 call that we just discussed, indicating that at 3:51, well, I had to find it, 3:51, it turns into another case, and to redact that to the end. We agreed. Video 3 in that file, again, no file name, indicates at 9:40 to 9:43, there's a redact request with paren previous arrest. The state agrees to that. We heard her quickly say that at 9:43, and we will get that taken care of.
So in one of the body cam videos, Sarah says, oh, but I was arrested, something about her being arrested before. And of course, the defense wants that out, and the state is going to agree. So you might wonder why they would agree to that. And one reason is because they know that the defense could successfully argue it anyway. So why bother wasting everybody's time with that? Because Sarah's behavior and the crimes speak for themselves loudly enough. The other, I think, more subtle thing, though, is that if the defense doesn't want that introduced, it might be okay to not introduce that. Because one of the things that Sarah could claim for the night of the crime, she could claim, I was afraid to call 911 because the last time I did, I was the one who got arrested, and use that to prop up her assertion that she's afraid of the police, right? So if that's not introduced, then, then it's harder to use that argument, right?
Then their next response was 6/18/2019 case, which I had to cross-reference back to show that it is OCSO 19-055572. And in that particular case, what I sent them was a screenshot that includes the OCSO case number 19-055572.
Hey, Shawnetta is in the chat and you're in the courtroom. That is awesome. So everyone in the chat, if Shawnetta is reporting on something, I hope you notice it. If it's something you think I need to see, holler at me. Okay? Thank you.
And it indicates there is an intent by the state to introduce 2 911 calls and 1 video file labeled axon_flex_2_video_2019-06-18_1330. My response that I received from them was video 3 in file, 2 minutes 7 seconds to 2 minutes 18 seconds paren ID, and then video 4 in file, 2 minutes and 4 seconds to 2 minutes and 16 seconds paren ID. So my confusion lies in I did not indicate 3 or 4 files. It was just 1 file. And then again, with the other 2...
I don't want to address 4 and 5 yet.
Okay.
It's my understanding there's no response. We'll address that momentarily. Responses to the clarification as to what it is the state seeks for incident 3.
No redaction.
Okay, all right. With regard to incidents 4 and 5, Mr. J, could you place on the record what it is specifically as to those incidents the state may be seeking to introduce?
Yes, sir. So what we're calling incident number 4 should be OCSO 19-078009, August 28th, 2019. We indicated the desire to use axon _flex_2_video _2019-08-28 _2024. And then at their request, they had desired to get photos of Ms. Boone's injuries from that case. There is a 19-page PDF file which has pictures taken by law enforcement of her injuries. I don't see anything else in there. One picture of Mr. Torres, a couple pictures of Mr. Torres, but nothing that the state was objecting to. So that was at their request that they wanted photographs in. So that is incident 4, which is labeled OCSO 19-078009.
With regard to seemingly the body-worn camera that the state seeks to enter into evidence from August 28, 2019, what say the defense?
John, I don't know about the state's position on this. There's a portion of this video at the very end that's very personal to an investigating officer that they may want to redact. We're not asking anything to redact.
Is the state seeking any redactions?
I'm just clarifying what their redaction requests are in that particular file.
Okay.
If they don't have any, then
So are there any redaction requests with regard to that particular file?
No, Your Honor.
Okay. I'm just keeping notes. Give me a moment, y'all. As to the 5th incident, Mr. J.
No redaction request, Your Honor. I do want to point out that we were apparently advised yesterday that the state was only going to use the 3rd video possibly. And so we haven't really spent a whole lot of time worrying about it since then.
Let me clarify as to what the 5th incident is, just so that we're all on the same playing field.
Okay.
Judge, the 5th incident is OCSO 19-079759, and that was on September 4th of 2019. Within that screenshot that I sent to them, both Friday and then resent it this morning, was photographs of the defendant taken at that time. At their request, shows a cut in her ear. It's 3 photographs. Then there is also one body-worn camera labeled 1924755. Strike that. 192473549 _GEN_INV, and then the 911 call from that incident.
Any redactions sought by the defense with regard to that specific body-worn camera or 911 call?
Well, we're not necessarily seeking redaction, Your Honor. However, there are 2 separate videos. One seems to focus on Jorge Torres. One seems to focus on Ms. Boone. And there is clearly some redundancy. They're both body cams. One went upstairs where Mr. Torres was found hiding in the shower for bath. And so some of that's redundant, but there are actually 2 separate videos pursuant to the 5th.
Mr. J, J? Are there one or two videos that the state's seeking?
There's one, the one that I listed in the file, not important for.
Okay. Do you know if that's a... Bruce, can you find out what counsel's here for? Is that the video from the perspective of, as identified by Mr. Beck, one more geared towards Ms. Boone or one more geared towards Mr. Torres?
My interpretation of both of them is there's interactions with Ms. Boone, and then there's interactions with Mr. Torres upstairs after he's located.
Mr. Beck, the specific file number was identified. So just to confirm, no redactions? Okay, all right. So just as a recap, with regard to the first incident, the 911 call, the parties have agreed to redactions at the timestamp of 351 towards the end. With regard to the second incident, body-worn camera, a redaction from timestamp 940 to 943 has been agreed to. With regard to the June 15, 2019 incident, there are two 911 calls and one body-worn camera sought by the state to which the defense has no redactions. The August 28, 2019 incident for which there is no redactions to the body-worn camera, but there is a 19-page PDF with photos that the defense intends to be included with that submittal, to which the state has no objection. As to the fifth event, 3 photos of the defendant, body-worn camera, and a 911 call for which there are no redactions. Does that clarify everything for the state?
Thank you.
Is there anything that I stated incorrectly, Mr. Beck, Mr. Henderson, or Mr. Owens?
No, Your Honor.
Okay, thank you very much. Moving to the next issue with regard to the 119 pages from Winter Park. Defense, are you in a position to provide, I believe we discussed it either Friday or I think it was last week we discussed it as to how it was culled down. Yes, because we had the Richardson hearing on Friday. How that list was culled down and the additional pages that the state was seeking. And then if they were able to find, I believe it was page 68, we would readdress that. Have you provided that finalized exhibit to the defense as to those specific Winter Park health records from the 119 pages that the defense may be seeking to enter into evidence?
I believe they've received everything from us, Your Honor. We identified those documents that were not specifically addressed by the defense, that the state wanted extension out of rule of completeness. I believe we're...
But my understanding from Mr. J was that they were looking for the tangible copy of what it is that you were actually looking to move in. Those 12, 14, 15 pages. Okay, if you could provide that to them by noon, I would appreciate it.
They're going back to FedEx. I just saw someone in the chat refer to Timu lawyers. That's hilarious. You guys are a riot.
That's what we're saying.
But if it's going to be moved into evidence, we have is it going to be moved in paper form, or is it going to be moved in digital by virtue of a CD?
We can get it, Judge. We'll work on it.
Okay, perfect. Just get it to the state. It doesn't have to be intangible. Just get them what it is that if it's an electronic format, that's fine. Just the state should be entitled to know what it is that y'all are intending to move out of those pages just to confirm it. Lastly, with regard to hospital records of the victim, I know there were conversations and discussions about that list being narrowed down. The state has advised that details as to those narrowed down records has not yet been provided. What say the defense?
The hospital records for the victim, George Torres.
That's my understanding.
He's acting dumb. He knows exactly what they mean.
We need to do that, Judge. We've got to do that.
Okay. My understanding is that the experts are potentially teed up to testify tomorrow. I don't recall if those records are a basis of the experts' opinions.
Well, the second expert is not likely to testify until Thursday. She's testifying in Bay County tomorrow. I will be here Thursday, and I spoke with Dr. Brandon last night. He will be present tomorrow morning as soon as he gets here from Colloquy.
Did either Doctors Brandon or Harper rely on those medical records?
No.
Dr. Harper did. It's in her deposition that was taken a couple of weeks ago. I think the question was posed.
Ms. Perez, good morning. If you're here for pretrial, 19 Alpha, Judge Myers is covering.
I would have
Okay, thank you. You may continue.
Dr. Julie Harper, I know she considered the records of George Torres, and we took Dr. Harper's deposition, I believe, a couple of weeks ago. She was asked by the state about everything that she relied upon, and she did indicate that. Are we going to use or attempt to introduce those records? We'll pare it down if we are.
Okay, you've got till 5 p.m. today to advise the state as to what of those culled down records you're going to be utilizing. So they have the opportunity to review those in advance of Dr. Harper testifying.
And I apologize to Madam Court Reporter for speaking on top of each other. Dr. Brandon is testifying as a subject matter expert. He does not have specific familiarity with this case, and so there are no medical records or any other records that he has relied upon other than his knowledge and expertise.
Okay, all right. State, any other issues we need to address with regard to the discovery issues that you brought to the court's attention this morning?
No, sir.
Okay, all right. Moving now to the motion. I have reviewed that motion.
Judge, we were not aware of the motion until he made mention of it, so we need some time for the lawyers to review it, for us to.
So Mr. J needed to file a motion, and so he did, and he filed it properly and all that. But now Owens is saying, well, gee, we haven't had time to look at that. Meanwhile, Owens does the same thing to the prosecution constantly. That's hilarious.
Discuss it and to see whether or not it has merit or not.
Okay. It was e-filed last night, looks like 9:37, and then sent courtesy copy to myself through Ms. Barrios and you, Mr. Owens, at 9:38 last night. I'll give the opportunity to review that, and we can address it after the lunch hour. And that'll give the court the opportunity to do any research during the lunch hour on it as well. All right. Anything else, Mr. J?
I looked at it briefly. I'm not for sure exactly what the allegation is. I don't know if we need to talk about that. Excuse me?
I'm not.
Can we approach the bench?
Sure. Come on up, yo.
I think Judge K is giving them leeway because he doesn't want Sarah to have any reason to have an appeal. A. Silver is saying, be nice to Owens. It's his first day being a lawyer, I assume. No. Owens knows what he's doing. He's not a dummy. People are saying, yeah, I love Judge Kranick. Yeah, he is the perfect judge for this case. He's terrific. Colette is asking, Mr. J found a conflict of interest on the defense's side, ? I don't know. I don't know what the conflict of interest is, or the potential conflict of interest. And somebody was asking in the chat, is it usually this disorganized? Very often when you're in the courtroom, this is your workplace, right? So very often you are working things out while you're on the record. And it's better for them to do it now than when the jury's there and then they have to excuse the jury and then bring them back in. It's better to get it done now. I think I suspect Owens is purposely disorganized and purposely late. I don't know. I don't know the man. Joyce says Judge K has just the right amount of snark, but he does it without being too obvious. Yeah. He's the kind of guy, you want to go have a beer with that guy. Or a glass of whiskey or whatever he drinks, if he drinks anything. Because he would be funny when he doesn't have to be judge-like, right? Giovanna says Kranick has boundaries and a timeline. Kranick is also a very clear thinker. He's logical, and the way you can see the way his brain works, he's very organized, and he's no stranger to lawyers' shenanigans, so he can spot that stuff. There have been times, sitting in court, and the lawyers are doing something, and they're using proper language, and their demeanor is calm, and because you know them or you've seen it before, they're playing a game, but the people behind you, the public viewers, have no idea what is actually going on. But the judge knows this stuff. Iran says, Kranick seems like he'd be a good dad. Yeah, I would love to be mentored by someone like him, or to learn from someone like him.
All right, thank you all very much. With regard to that motion, we're going to table that for now and address it potentially this afternoon. State is advised they're ready to proceed. Mr. Jay shook his head yes. Defense, you ready to proceed? Mr. Owens, you ready to proceed, sir?
Yes.
Thank you. All right. Ms. Boone, are you still satisfied with your lawyer's representation of you in this matter?
Absolutely.
Are you still on board with the strategy that they have employed in the use of your defense?
Yes.
All right, let's go ahead and stand and bring in our panel.
I forgot to fast forward through that slow part.
12 Alpha of the Orange County Courthouse. Thank you again for your time, your attention, and your sacrifice in this matter. Just by a show of hands, if you could confer that you complied with the court's instructions last night. The record will reflect all juror members have raised their hands. All right, State, if you could please recall Detective Kepsel.
State would call Detective Kepsel.
Please swear or affirm the testimony you should give shall be the truth, the whole truth, and nothing but the truth, so help you God.
Ma'am, good morning again. Could you state and spell your name for the record?
Yes. My name is Chelsea Kepsel, Chelsey, Koepsel.
All right. Mr. Cacciatore, you may proceed.
Your Honor, we had tendered the witness to the defense.
Okay, thank you. Mr. Henderson, you may proceed with any cross-examination.
Good morning, ma'am.
Good morning.
Now, it's my understanding that on February 24th of 2020, you responded to this crime scene. Is that correct?
Yes.
Were you the first officer to respond to the crime scene?
No.
So there were other officers who were there prior to you arriving. Is that correct?
Yes.
Were you the first detective to respond to the crime scene?
Myself and my partner, we all arrived at the same time because we left from the same location at the same time.
Okay, and who is your partner that day?
Detective Scott Lowen.
And throughout the whole time, you and Detective Lowen worked on this case together. Is that correct?
Yes, he assisted me with this case.
Now, when you arrived on the 24th, approximately how many other officers were there?
Including like deputy sheriffs, like in uniform?
Yes, ma'am.
Yes. Approximately 4, maybe, I would assume.
Had it been designated a crime scene at that time, and had tape or security measures been taken to protect the scene?
Yes, they had.
All right, so that had already been done by the time that you arrived. Is that correct?
Yes, that's correct.
Okay. Now, in the investigation, one of your or what you're trying to accomplish in the investigation is basically get a basics of what took place. Would you agree with me there?
Yes, I would.
All right. And you can do that one or two ways, or a combination of ways. One is to take testimony of potential witnesses. Is that correct?
Yes, it is.
All right. On this day, did you in fact do that?
Yes, I did.
And one of those potential witnesses was Sarah Boone. Is that correct?
Yes, it was.
And you took a statement from Sarah Boone because we've all seen it. Is that correct?
Yes, we have.
And at that point in time, Ms. Boone did not have to talk to you if she didn't want to, did she?
No, she did not.
So she agreed to talk to you at that point in time?
Yes, she did.
Okay. Were there any other witnesses besides Ms. Boone that you talked to on this initial date of the 24th?
Just Brian Boone.
And Mr. Boone told you what? You had a chance to talk to him. He told you his involvement. Is that correct?
That's correct.
And in fact, wasn't Mr. Boone's testimony, was that recorded too?
I conducted an audio recording, yes.
Okay. Is that standard procedure when you do your interviews to try to record the interviews?
Yes.
What's the benefit of that?
So I know what was said.
Okay. So, and if something goes on for a long time, you can refer back to it. Is that correct?
Yes.
Okay. All right. So, and out there, that's part of talking to witnesses or potential witnesses. Okay. Also, it's your job too to identify potential physical evidence in a case.
Yes, it is.
All right. And in fact, on the 24th, did you do that?
Yes, I did.
Okay. Did you have anyone assisting you in doing that aspect of it?
Yes, crime scene investigators and digital forensics investigator.
All right. And was Miss Melissa Roffengarden, is that how it's pronounced? Pronounce it for me.
Rough Garden.
Roffengarden. Okay, thank you. Did she help you in that area?
She was the lead crime scene investigator, yes.
Okay. So were y'all walking around together? Give the jury an idea of how that process takes place, please.
So yes, when I initially arrived on scene, I introduced myself to Sarah Boone and explained that I wished to go inside her residence, which she gave me consent to go in and look around. I went in, looked around, and then when my CSIs arrived, they would go in, take pictures, and then I kind of leave them to do what they need to do as far as taking pictures and documenting things and measurements. And then that's when I conducted my interviews. And then I would meet back up with my crime scene investigator after interviews were conducted to kind of follow up with like things that I was told that would help us like identify things from the scene. And so, I mean, there's like multiple occasions where I would have met with my crime scene investigator inside the residence.
So this is an ongoing process during that day. You get information, you consult with them, they have information, they consult with you, and you're making a determination of what potential physical evidence that y'all at least like to document by camera, correct, or pictures, or actually collect and take away. Is that correct?
Yes, that's accurate.
All right. In that case, the suitcase was some evidence that y'all agreed on that we need to take this suitcase from the scene. Is that correct?
Yes, it was.
Okay. How about the baseball bat? Was that done that day?
The baseball bat was collected, yes.
All right. In your viewing of the suitcase, did you view the suitcase while it was unseen?
Yes, I did.
All right. Did you notice that if there was any items, other independent loose items in the suitcase?
There were, yes.
Were those items collected?
Some of them were, yes.
Who made the determination what items of that suitcase would be taken or collected and what would not be collected?
I would say that I have the final say on what is to be collected or not collected, but we do discuss it together to make that determination for me to give the final yes or no.
Do you recall which items you decided to collect from the suitcase?
Do you have the property form that I can refer to?
No, I'll try to find it.
I know some of them, but
You know he's going to go for it, but why didn't you do this and why didn't you do that?
Ma'am, I don't have it, but to the best of your memory, can you tell? And I would understand there would be some stuff that if you had the property report to refresh your memory, you can give me more detail.
yes, to my understanding and to my recollection, we collected things that had blood left over on it. I want to say there was like a necktie potentially. I do recall there being a small amount of clothing and miscellaneous paperwork, but I do not think that we collected the paperwork. There was also a cell phone in there. It was not, it was dead, the cell phone. And then, like I said, there might be one, I think we collected 5 to 6 items from the suitcase itself, but obviously the property form would tell you specifically. But that is what I recall.
Correct, and I understand, and that's fair. Okay. So potentially you collect these items because you believe they're evidence for the case, potentially. Is that correct?
Yes.
And some of these items you actually collect with the potential that you might need to have them examined in greater detail. Is that correct?
Yes.
Okay. An example of something like that would be in this case, if you found blood on something, you might want to potentially examine that. Is that correct?
Yes.
And also the stuff that you're learning outside of these items also helps you in making that determination. Isn't that correct?
I'm sorry, one more time.
The stuff that you learn, the information that you're getting or you're receiving about what happened at that time will lead you to determine what items might need to be collected and what items might need to be tested.
Correct.
Is that correct?
Yes.
Interesting. So Henderson is correct when he says the information that you have, so what you believe happened or could have happened, helps to inform what you decide to collect and not collect. And an example of this is earlier in the comments, somebody had said, well, would they collect sort of paint samples from the walls to see if, any paint chips got on the suitcase as the suitcase tumbled down the stairs? Well, the answer is, well, why would they think of that? It's such a bizarre out there thing. They didn't have any information that suggested that. So why would they think of that? So Henderson is correct. And I think this sets up the defense for 2 things. One is to say, well, why didn't you do this and didn't you do that, right? The other thing, though, is if Sarah's coming back with a completely different story that the detectives never heard, and there is no evidence at the scene that would support her story or corroborate any element of her story, well, the defense can say, well, the detectives just missed it, and nobody knew, right? So, yeah, interesting.
All right. So out of the items that were collected at the house or the apartment, at those items, was anything to your knowledge sent off for further examination?
I believe so, but if it was, they would be sent to the Florida Department of Law Enforcement for further testing.
Okay. And do you have an independent memory of what items that were collected from the house that were sent to FDLE for further examination?
I don't recall specifically without looking.
Okay. Now, are you aware at one point in time there were some fingernail clippings or fingernail swabs taken from Miss Sarah Boone? Is that correct?
Yes.
In fact, that was done on her interview date on the, would it have been the 25th?
Yes, sir.
Is that correct?
Yes.
Okay, and that's what we witnessed in the video.
Yes.
That's what they were doing at that time, correct? And I'm sure at the autopsy, which you were present at, is that correct?
Yes.
And those, there would have been some fingertip swabs of George Torres. Or are you familiar with that?
They do swabbing of the hands, to my understanding, and clippings of his nails.
Okay. Do you have an independent memory of the fact that Sarah Boone's fingernail swabs were sent to FDLE for comparison?
I would believe so.
Okay. How about the ones from Mr. Torres? Do you have knowledge that those were sent to FDLE for comparison or identification?
Well, they would have come from him, so I'm not sure what we would have compared him to.
Okay. Were they there to see, or at least they're sent there to see if they can extract DNA?
Oh, okay. Yes. I mean, I'm not sure if they did that testing for his nails clipping specifically, but it would be in the report if so.
Okay. Who would make the decision about sending his finger swabs to FDLE for comparison or evaluation?
I would request it I would request it to the crime scene investigator, and she would author the, I guess, procedure for them to do so.
Okay. And then as to Sarah Boone's swabbings, who requested that those be sent to FDLE for evaluation?
Again, I would assume that I would have done that. I would have requested the CSI to do that.
Are you aware of the results from those evaluations? I'm not asking you for the results, just if you're aware of the results.
I believe I'm aware, but would love to see a report before I specifically answer.
Yes, I'm not going to ask you a specific question about it, okay? All right. But basically, you're aware that it was done, the procedure was done?
Yes.
The analysis was done, okay. Now, ma'am, so you're through the first day, then we get to the second day, which would have been, I believe, the 25th of February, is that correct?
Yes.
And on the 25th of February, was Mr. Torres' autopsy done at that time?
Yes, it was.
Were you present during the autopsy?
Yes, I was.
Okay. And did you communicate with the medical examiner at that time?
Yes, I did.
During the course of things, is that where you found out through the medical examiner at the autopsy that there was blunt force trauma injuries?
Yes, that is where I learned more about his injuries.
Now, initially, when you were on the scene on the 24th, did you view Mr. Torres' body?
Yes, I did.
Did you notice in and of yourself on your own something that caused you concern that there might be blunt force trauma injuries?
Yes, I noticed injuries to him, yes.
Okay. So after the autopsy, you had additional information, is that correct?
Yes, I did.
Now, there was an interview, well, I don't know if it was an interview. There was a meeting set up for Sarah Boone, is that correct?
Yes.
On the 25th? Is
Yeah.
that correct?
Yes.
Can you tell me how that meeting was arranged or how that meeting was set up, please?
So either before I left the scene, the night of the incident, I obviously met with Sarah and told her that we were leaving. We had to go make next of kin notification, and I would have either at that time said I would like to meet tomorrow and arranged it then, at least to like let her know that I would like to meet after the autopsy, and then obviously from watching the video towards the end, she said something about like recalling a conversation that we had, like calling me. So there may have been a phone conversation that occurred later that evening where I either would have confirmed the time or told her the time then. I just don't have that like on an audio. But I know it either took place before I left the scene because I obviously would have, said my goodbyes and told her, hey, we're leaving. We're going to make next of kin notification. She was very concerned about that. So I would want her to know that we were doing that. So it either took place then or it took place on that phone conversation that we had.
Okay. All right. The day prior to that, on the 24th, ma'am, you received Sarah Boone's phone. Is that correct?
Yes, her phone was on the scene, yes.
And when you received that phone, Sarah Boone had given you that phone. Is that correct?
No, she was not allowed in the apartment to give me the phone.
I'm sorry. Did she give you permission to take the phone?
Yes.
Okay. Is that correct?
Yes, I was given permission to go through her phone, yes.
Because at that time, you hadn't applied for any type of search warrant to get or search the phone. Is that correct?
No, it was based off of consent.
Okay. So she had consented to you for you to have her phone.
Yes.
Is that correct? She also provided you the code to get in the phone. Is that correct?
Yes.
So they're going to go for how Sarah is so cooperative. So she's so cooperative, yet she's afraid and lied to them. And they might frame this as capitulation rather than her being honest. We will see.
So at this point in time, Ms. Boone is cooperating with you. Isn't that correct?
Yes.
Now, ma'am, do you recall telling her, Ms. Boone, that she could get her phone back the next day?
I don't recall specifically telling her when she would be able to get her phone back, but I did say something along the lines of we were now going to be taking the phone. I obviously had digital come out for consent to go through her phone. There was evidence on her phone that I needed to be downloaded. And at the time, I was willing to give back her phone before going through it. And then once we had gone through it, and those videos were found, I felt like this was very different, and it changed my perspective on consent. And I decided at that time that it was best to write a search warrant. So consent couldn't be basically like I knew I was going to take her phone. So consent has to be basically given to me throughout the entire period. So she would have had no way to contact me to tell me she no longer consented. So therefore, because there was evidence on the phone, I took the phone. Basically, I potentially told her, maybe we didn't get a full download. I may have said something along the lines of that. As far as me taking the phone, and then I wrote a search warrant. I either started writing the search warrant the night of, but it wasn't signed until, I didn't submit it until the next day, and then it was signed the next day, on the 25th.
So basically what you're telling us is that she could have withdrawn her consent at any time prior to that search warrant being received. Is that correct?
Well, while I was on scene, but at the end of the day, there was evidence on the phone, so I knew I could go through I knew I could get a search warrant to go through the phone based off there being evidence.
So I want to make a distinction here. She could have withdrawn her consent for them to search the phone, but she couldn't have withdrawn her consent for them to seize the phone. Search and seizure are different things. So they've got the phone. She gave consent for them to search through it, and she would have had to give continuing consent for a continuing search. Chelsea knew that there was no way that was going to happen, so got a warrant. So Chelsea has not done anything wrong, and in fact, the digital forensics expert yesterday testified that Chelsea instructed her to stop the download, so that search was stopped. So Anderson is not going to get an illegal search issue here. And I wonder what the jury's thinking, because, they're not going to be parsing all this down.
Like the 911 calls, and her explaining to me that they had spoken to family members.
Please silence your cell phones.
Since they had explained to me that they spoke with family members the night prior. So I wanted to obviously corroborate her statement. So I knew that I would be able to get into the phone through a search warrant. But yes, she could have not consented, and she could have not signed the paper consenting while we were on scene.
Okay. But before you left scene, you knew that Sarah Boone was not going to get that phone back. Is that correct?
Yes, that is correct.
Okay. So when Sarah Boone called you the next day, asking you about bringing her phone back, did you just tell her, Ms. Boone, you're not getting your phone back?
There was not a conversation about her not getting her phone back. She may have inquired about her phone, and I would have explained that we will talk about it when we meet that afternoon.
Okay. So, did you reach out to Ms. Boone that next day, or did Ms. Boone reach out to you?
I don't recall a specific if she reached out to me the night of the 24th or before the interview on the 25th. I don't have my call records for that. I'm just basing it off of the interview where she had basically said that, yeah, I have your business card and I can contact you like I did. So my assumption would be that we did have some sort of conversation either the night of the 24th or before the interview on the 25th.
On the 25th, did you make arrangements with Sarah Boone to meet with her on the 25th?
So I either made arrangements on the 24th with her before leaving the scene, and I would have told her I would like to meet with you the next day. Or I said, and I may have given her a specific time at that moment, or when we spoke later that evening on the phone, I may have confirmed the time or given her a time then. But she definitely knew that we were meeting at 3 p.m. on the 25th at Orange County Sheriff's Office Central Operations.
And ma'am, you just don't remember at what point in time you informed her to set up this meeting with her. Is that correct?
It's one or the other.
One or the other?
Yes.
Okay. As to it being one or the other.
This has got to be hard for the detective because it's such a minor routine thing that you do. So this is when, a defense attorney starts questioning this. It gets challenging to recall, specifically this case that happened 4.5 years ago. When did you never know what you're going to be asked. Like, when did we set up the interview and how? So you just never know what a defense lawyer is going to ask you that you have to remember.
You did the You prepared the investigative report in this case, is that correct?
Yes, I did.
And the investigative report, you basically summarized everything that took place on this case, up to a certain point.
Yes,
Is that correct?
it was a summary. Yes.
All right, as far as evidence, as far as witnesses who were talked to and synopsis of what they said to you at that time, is that correct?
Yes, things that I did specifically. It was a summary of that.
I found your investigative report to be in great detail because it helped me track this case from basically beginning to not to the end, but to the point where the inquiry stops. And it seems like in your investigative report,
Here we go. This is where, if you're a police officer, you cannot win. If you aren't putting a lot of detail into your notebook, into your reports, the defense lawyer is going to get up and say, these are important details. Why are they not included? Right? Why is this report basically so bad? But if you do put a lot of detail in and you miss one because you don't have ESP and you don't know what a defense attorney is going to come up with to pick on, 4.5 years from now, because, you don't have a crystal ball, the defense attorney is going to say, you have all these details in your notes or your report, but not this one. Why not? So it's a game.
you are very thorough about details. Is that correct?
I would say I'm a detailed person. Yes, thank you.
Okay. So being the detailed person you are, and absolutely doing your law enforcement training, they tell you, they train you that your report should be very much in detail. Is that correct?
Yes.
Okay? Because you might have to refer back to them at a later time. Is that one of the reasons? Is that correct?
Yes, and to prepare myself for depositions and trials.
Okay, and just to give an accurate picture of what you did and what took place and what people told you. Is that correct?
Yes.
Okay. Being as thorough as you are with these contacts with people, I didn't see in the investigative report when the arrangement was made with Sarah Boone to meet you down, and where did y'all meet?
The Orange County Sheriff's Office, Central Operations.
To meet you at the Orange County Sheriff's Office. I did not see that in the report. Do you have an explanation why?
It's not typically something I would put in my report.
I'm laughing here. I mean, look at the look on her face. She knows what he's doing, right? She saw where he was going with, just like I did. It's hilarious.
Okay. Do you remember in having the conversation with Ms. Boone about this meeting that was supposed to take place, that you said that you could not return the phone to her that day because you were not feeling very good? You remember telling her that?
That never happened.
Okay. Ma'am.
Do you see how effective that was? If there was a chance that something could have happened, if she wasn't remembering clearly, she's saying, well, maybe, and I think I probably did, et cetera, et cetera. And this is where being honest and being honest about even what could look like your failures is a good thing. Because when you know that something happened or didn't happen, you can come across like this, where she just asserts that never happened. And that makes her more believable because she has not been defensive at all. I'm loving her.
Judge, if I could have a moment.
Yes, sir, of course.
Ma'am, during this time frame, were you pregnant at this time? At that time?
Yes, I was.
Okay. All right. Well, anyway, Miss Boone.
Excuse me, Mr. Henderson? Really? So Sarah Boone, I think, is the one who used Chelsea's pregnancy. And everybody saw, the jury saw body cam, the videos. They know. So why is he throwing that in there? That irritates me. It's crappy.
There was a meeting arranged. Is that correct?
For the 25th at 3 p.m., yes.
Yes, and Miss Boone showed up for that meeting.
She did.
25th.
Yes.
We saw it. Okay. Now, ma'am, I'd like to talk to you about some other investigation. On witnesses, other witnesses that you took their testimony or statements, recorded statements at different times. Okay? Do you remember Abraham Moreno?
Yes.
Okay. Did you take his recorded statement?
Yes, I did.
All right. At the time that you took Mr. Moreno's recorded statement, was there anyone else with you?
My partner should have been with me, Detective Scott Lowen.
Excuse me?
My partner should have been with me, Detective Scott Lowen.
Okay. Ma'am, as to who was with you, would it help refresh your memory if you were to see your investigative report as to that interview?
Your Honor, I would object. She hasn't said that she needs any aid in refreshing her memory.
Objection sustained.
Ma'am, was Detective Scott Lowen with you during that interview?
Yes, I believe so.
May we approach?
Yes.
Wonder what he's going for. And all of this has nothing to do with what Sarah did.
Entire interview audio
Whoops.
recorded.
I
Sorry.
believe my partner was with me on the interview, yes.
Ma'am, do you have an independent memory of Detective Scott Lowen being with you at that interview?
I believe my partner was with me on the interview, yes. I typically wouldn't go and do some follow-up without my partner being with me.
Thank you very much. Now, ma'am, did that interview, what date did that interview take place on?
I believe the 26th? February 26th of 2020?
Okay, thank you. Ma'am, was that interview recorded?
It was audio recorded.
Was the entire interview audio recorded?
Yes, the entire interview was audio recorded.
sure where he's going
Ma'am?
with this.
Are you familiar with a witness by the name of Brandon Moats?
Yes, I am.
On February the 27th of 2020, did you interview Brandon Moats?
I believe so. It's either the 26th or 27th, yes.
If you were to see your investigative report, would that help refresh your memory?
All right, I would again object. She hasn't indicated that she needs assistance with her memory.
Approach.
What is he doing? Anyone have any ideas here? Is he suggesting she doesn't remember, or suggesting she is incorrect or lying?
Objection sustained.
Ma'am, if it was the 27th, you would not disagree with that, would you?
Well, I just stated that it was either the 26th or 27th.
Okay, thank you. Ma'am, Mr. Moats, he was the neighbor living in the apartment, or the connecting apartment, wall apartment, with Ms. Boone and Mr. Torres, is that correct?
Yes.
And he's the one who told you about the loud noise, is that correct?
Yes.
Okay. Did you interview anyone else in reference to that loud noise?
So I was interviewing Brandon, and then my partner was interviewing Vincent, the other witness, and I came in at the end of the interview with Detective Lowen.
Okay, so that's Vincent. Do you know his last name?
I would butcher it.
Me too, but Taglione, something like that. We're talking about the same person?
Yes, sir.
Okay. And did that interview take place on February the 27th of 2020?
I believe so. I interviewed witnesses after I interviewed Sarah. The 26th or 27th would be my memory.
Okay, thank you. And then, did he also talk to you about a loud noise?
I believe that I was refreshed on the conversation, and yes, he expressed hearing a loud noise as well.
Okay, thank you. Now, and those interviews were actually audio recorded too, is that correct?
Yes, they were.
Now let's go to Ms. Boone's interview. And that would have took place on the 25th, is that correct?
Yes.
Okay. And Ms. Boone came down. And, ma'am, prior to Ms. Boone coming down for the interview, had y'all made the decision that Ms. Boone was going to be arrested?
Yes, I plan to arrest Sarah Boone.
Okay. Did you tell Ms. Boone in arranging the meeting that when she came down there, she was going to be arrested?
Your Honor, I'm going to object this for relevance.
Approach.
The detective doesn't have to tell Boone that. They can get her down there on any pretense they'd like. And if Sarah had come down, talked to them, and gave them some compelling explanation for what they'd seen on her phone, then, you know, maybe they would change their mind. Now, I don't think so in this case, but, you know, I'm not sure what he's going for here, except that Sarah wants him to go for something. Sort of like she is the victim, she was tricked, but we've been through this. This court has been through this during motions in limine. So I think part of this is a show for the jury to show them, oh, poor Sarah is being tricked by the police and was afraid of the police, and that's why she would lie to the police. And the other thing, you know, the reason why, sometimes a reason why they might list all the witnesses a particular officer spoke to is if they're going to try to discredit the officer themselves and try and get everything, every witness they talk to, thrown into doubt. Don't know really where he's going here. And I wonder if the jury does.
So, ma'am, at that time, you did not tell Miss Boone, prior to coming down there, that she was going to be arrested. Is that correct?
No, I did not.
Okay. Why did you not tell Miss Boone that she was going to be arrested?
We planned to meet at 3 p.m. and go over the autopsy and have another interview. So, I mean, I'm not sure why I would tell her that she's going to be arrested. That would potentially cause her to flee, you know, not come, and then we have to go find her and make it more difficult for everyone.
Or potentially get an attorney to come with her.
She was read her rights that said that she has a right to an attorney, and if one cannot be provided for her, she will be appointed one.
I understand that. You read her those rights when she got there. Is that correct?
Yes, I did.
You didn't read those rights to her before she got there, though, did she?
I wasn't.
Oh, that is slimy. She was not required to read the rights before she got there. And by the way, Sarah was read her rights the day before in the car interview, right at the beginning. So the defense couldn't make this argument before it fell flat. So now they're just trying the same thing in a different way, but this time it's in front of a jury. And none of that negates that suitcase video and Sarah's shh at the end. I'm ticked.
In contact with her, like physical contact with her.
Okay. So, but you said potentially for fleeing. My question was, potentially she could have got an attorney too to come with her. Is that not correct?
I misunderstood your question. I didn't hear potentially bring an attorney with her, but yes, I guess she potentially brought an attorney with her.
So Miss Boone shows up, and you tell her that some things that we need to talk about. Is that correct?
It's specific verbiage. I know I said something along the lines of, obviously the autopsy had been conducted, and there were things that we needed to talk about in regards to that.
And prior to discussing it with her and asking her questions, you did read her Miranda warnings. Is that correct?
Prior to, I'm sorry, one more time?
Before you started asking her questions, though, in this interview, before you started asking Ms. Boone's questions, you read her Miranda warnings. Is that correct?
Yes, before I started asking any sort of potentially incriminating questions, she was read her Miranda warnings, yes.
Okay. Ma'am, do you remember, as part of the Miranda warnings that you read to Ms. Boone, did you read her the one that states that if you decide to answer questions but want to stop answering and consult with an attorney, you may do so. Do you independently?
I object. I object. I object. That is not what the law says. That is what somebody's policy says. That is somebody's practice. This was argued in front of the court, but now he's trying to argue this in front of a jury who doesn't know, who aren't going to split hairs like that, who are just going to accept, this confrontation here. If I hope she doesn't say I didn't have that card or I have an old Miranda card, because the jury might assume that her rights were being violated. I mean, yes, the prosecutor can try and clarify that on direct. I hope Mr. J objects. If you're ahead, please don't put in any spoilers in the chat. Oh my gosh.
Remember reading Miss Boone that instruction?
I don't recall that specific, but I do have my Miranda card on me, but I don't recall that that's what that says. But it is on audio and video recording.
Okay, thank you.
You're welcome.
Now, ma'am, at that point in time, Miss Boone wasn't under arrest. Is that correct?
Ms. Boone was not going to be free to leave once she was in my custody.
At that point in time, had you told Miss Boone that she was not free to leave?
No, I did not.
At that point in time, had you told Miss Boone that she was under arrest?
I told her at the end of the interview.
Okay, before the interview.
No, I did not tell her before the interview.
Seriously. So he's now, if he wants to argue about Miranda, he actually is arguing against himself. If he wants to go with Boone's perception, because Boone's perception was that she was not under arrest. Her perception was that this is not a custodial interview. So he's going, and he knows that under the law, like all of this has been settled, right? But now it's in front of the jury. So now he's going to paint her as this poor woman that you got in there and you tricked her. You tricked her because that's what Sarah feels. I don't know. What do you think? You think the jury is going to buy this? You think they're rolling along with it? Do you think they've forgotten about that suitcase video already?
Ma'am, why didn't you tell her before the interview?
Your Honor, I'm going to object as to asked and answered.
Overruled.
So I have to read her Miranda warnings, and that's what I did. I do not have to tell her that she's under arrest at that time.
Was there a reason? Could you have told her that she was under arrest before reading her Miranda warning?
Your Honor, I'm going to object as it calls for speculation.
Sustained.
Ma'am, was it a strategic decision not to tell Miss Boone that she was under arrest prior to reading her those Miranda warnings?
Your Honor, I'm going to object as to relevance.
Approach.
Wow. I'm going to forward a little bit. Yeah, Nikki's pointing out they saw the 2-hour interview yesterday. Yeah. Blink Bunny says the interrogation that shows Sarah's personality. Yes. I'm afraid to fast forward too much. Hang on. So, yes, the judge already ruled on this, but now this is all, everything Henderson is doing is for the sake of the jury. He knows. They know. All know what the judge thinks. This is for the benefit of the jury. Mr. H says jury is like, we don't have time for this BS. Yeah. Is Chelsea looking at her watch? Jay-Z saying wasting the jurors' time. Yeah.
The objection is sustained.
Okay. So he can't go there anymore.
Ma'am, and we were able to see the video of the interview. As a process of interviewing people such as Ms. Boone, or well, let me specifically, in the process of interviewing Ms. Boone, is law enforcement free to give information that might not be accurate or true during the interview process?
Are you asking if we're allowed to lie to her?
Yes.
Yes, to an extent.
Was that done at any time in this interview?
Did I lie to her? I don't recall lying to her, no.
May I confer, Judge?
Yes, sir.
That's hilarious.
Thank you, ma'am. I have no further questions.
Any redirect examination?
No, Your Honor.
Can this witness be released? State.
We have her subject to recall.
Okay.
Subject to recall.
All right, ma'am, you're released subject to recall. Thank you.
Great, thank you.
State any other witnesses, evidence, or testimony to be produced?
Your Honor, at this time, the state would rest.
Okay. Members of the jury, it is 10:22 a.m. I have some matters with counsel that I need to address. So we're going to excuse you for a short while. It's a great opportunity for us to take our morning break as well. Similar instruction that I've given to you over the last couple of days. Please do not discuss this case amongst yourselves or anyone else. Do not conduct any independent research or investigation.
I'm going to see if we get to see the discussion with the lawyers.
Okay.
If we could do that, because it may be fairly lengthy.
Agreed. Let's go ahead and take that break. Court's going to be in recess for 10 minutes, and then we'll pick up any motion practice at that point in time. Court's going to be off the record. Thank you.
Okay, I'm going to fast forward. Here we go. All the way here. Oops. Okay, I'm going to check the chat here. And see what you guys are saying. GC points out that Chelsea didn't outright tell Sarah she wasn't under arrest. She just didn't bring it up. True, that's true. Yeah, you think Sarah's excited, you guys? I'd be terrified. So I'm going to switch screens here so I can see more of the chat and hope that doesn't mess me up. Here we go. I think the defense is really they're really trying to do the best they can. And, you know, if I was accused of something, I would want that. Jackie's saying she doesn't think any of Henderson's moves today did anything to sway the jury. Matt C. says Sarah's not scared. She can't wait. Romeo Saints is saying, I hope the jury will see how sneaky Henderson is. He seriously played dirty. I don't know that the jury is going to see that, actually. Remember, we have seen much more than the jury has seen. William Carl is asking, can the state show new evidence to dispute a defense claim? The state can show evidence on rebuttal. Yeah. So far, the state hasn't brought up a number of things because they don't want to open the door or because they're not allowed. But once the defense opens the door, the state can say, oh, yeah? Well, we have this, this, and this. This is part of the reason why a number of these witnesses are still subject to recall, because they may need to bring them back. Someone saying Watson is gorgeous. Thank you. Nikki's asking, do you think the prosecution will have a long redirect? I think you mean rebuttal. And I don't know. I think it's going to depend on what Sarah says on the stand. Everything's going to hinge on that. If Sarah does not give provide an overt act, then self-defense is not going to be allowed. But I suspect she's going to lie and do that. Kat's asking, can the state object at all during her narrative? So, yes, but they have to have reason, right? They have to have a legal reason for that. And sometimes a lawyer on one side or the other knows that he or she could object, and they decide not to. Sometimes they decide to let things slide on purpose. HRH Mom is saying, if I were on the jury, I would be annoyed. Yeah. I don't know. Someone's asking if Sarah's testimony will be narrative. I don't know. Loba, is asking who decides about the overt act and asking if it's the judge. Well, I mean, they could argue about that. Ultimately, it's the judge who would rule on that. But the judge has to really give the defense a lot of leeway. So if there is the tiniest amount of evidence.
On the record, 2020 CF 2603, State of Florida versus Sarah Boone. Appearances for the state.
Hang on.
That's sure on behalf of the state. William J. for the state.
Defense.
James Owens for Miss Boone. Tony Henderson.
Tony Henderson for Sarah Boone.
Kevin Beck on behalf of Sarah Boone.
Do we have any motions?
We do, Your Honor.
You may proceed.
If I may approach the podium, Your Honor.
Yes, sir.
Your Honor, at this time, the defense would move for a judgment acquittal. I'm going to start with just a real quick couple of comments, Your Honor. We know that JOA motions have become essentially pro forma, which may be why I've been assigned this responsibility today. But in this instance, I want to make an argument that I think has some merit.
So he's saying that these motions for acquittal are essentially pro forma, which means is, you know, we just always do this as a sort of a matter of form or a matter of course. And it's funny, he says, that's why I was assigned. And he says, but, Judge, my argument today actually has merit. So let's see what he says.
I've been paying close attention to the testimony in this case, and I want to point a couple things out. First of all, we know that the court has essentially assumed the role and is assigned the role of becoming a gatekeeper in this matter. We know from the testimony that's been presented in this matter that not only did law enforcement, but also the Office of the State Attorney had knowledge of these parties prior to the event having occurred. And despite that, the state has proceeded with this prosecution based upon criminal information as opposed to having taken it to the grand jury. That kind of places the court in a special position to evaluate the nature of the evidence that's been presented.
Oh, come on. So the state was aware, so that there had been prior incidents with Sarah and George. And so the state's aware of all this right from the beginning, that there was this back and forth. And so this lawyer is suggesting that this should have gone through a grand jury, not charged on an information. Well, the relevance or the issue of the previous back and forth would have been important, and perhaps they would have proceeded differently if the defendant in the case had claimed self-defense in the first place, but that is not what she did. She claimed not intentional. I fell asleep. So that makes the prior acts irrelevant up to a point. It wouldn't be part of the case if she's not claiming self-defense. So you can't retroactively argue something. That's frustrating.
I want to focus on the second-degree murder allegation. And one thing that occurred to me while watching the evidence as it was presented, watching the videos, particularly the interrogation, was part of the dialogue between Ms. Boone as well as Detective Scott Lowen at the end of the interrogation. And I'm going to paraphrase. I apologize. I should have written this down verbatim. I did not. But she's advised that she is being placed under arrest. Something to that effect. And her response is, "Why are you doing this?" The detective's response to Ms. Boone is, "Because George is dead."
I'm sorry.
Because George is dead. That's not enough. It's not enough to support a second-degree murder, prosecution, conviction, or should it even be enough to allow this matter to go?
All right. You cannot say that your statement to the accused is equal to the information that is presented in court, because they didn't spell it all out and all of the elements of the offense out to the accused at the time of the arrest doesn't mean that the state doesn't have enough evidence. Okay? And so if the argument is not that, if the argument is the arrest was improper because maybe they should have said you're under arrest for second-degree murder, but instead they said because George is dead, well, that issue is also easily remedied because she would have been given the information and her disclosure and all of that shortly after. So it's not like she's not aware of the reason for her arrest. And I think she doesn't say, why am I under arrest or what am I under arrest for? She's saying, why is this happening? So this argument is thinner than onion skin.
To the jury. Now, there are three elements of the second-degree murder information. The first is that the victim is dead, that Mr. Torres is dead. We stipulated to his identity. There has been no argument to the fact or the idea that he died in this incident. However, the state also has to show that it was caused by a criminal act and that the act was imminently dangerous and demonstrated a depraved mind. Now, the fact that it was imminently dangerous, I think, is belied by the fact that Jorge Torres voluntarily entered the suitcase, albeit under the influence of alcohol. But the perception of dangerousness that's attributable to the victim, apparently he did not perceive it to be a dangerous or an imminently dangerous situation.
Dude, save that for your closing arguments. And I really wish that they had proven that Mr. Torres did not get in there voluntarily.
Having entered the suitcase, possibly because of the influence of alcohol on his capacity to make decisions, should necessarily be attributed to the defendant as well. But I also want to focus on the depravity issue, which the state must prove, and pursuant to the jury instruction in this matter, depravity is equivocated, is made the equivalent of ill will, hatred, spite, or evil intent. And that's not enough. Not only does the state have to show depravity, but it has to show, because it's in the conjunctive, that the act demonstrates an indifference to human life. The state has presented.
So he's saying not only does it have to show the depravity, it also has to show the indifference to human life. I don't know. I can't breathe. F you. Kind of. I don't know. Do you think that might be indifference?
Presented testimony and argument in this matter, not argument, but testimony that in fact George Torres was suffering. Suffering does not equal hatred. It does not equal ill will. And even if they were to establish negligence, that's not homicidal. We know that suffering is something that the courts have been very, very cognizant of and very sensitive to. We know it from the field of capital punishment and incarceration. The idea that somebody suffers is not in and of itself homicidal, nor should it support the idea that there was indifference to the life of George Torres by Sarah Boone. Was she angry? I think there's clear evidence that she was angry. But that's not hatred. And that's the element that has to be proven here. And I don't think that there is prima facie case that in fact she demonstrated hatred so much as she demonstrated anger. Doesn't establish a prima facie case of second-degree murder. It's for those reasons, Your Honor, that I think that this matter should be, the motion for JOA as to second-degree murder should be granted, and this matter should be allowed to proceed solely on a manslaughter charge because, in fact, they have not established prima facie elements as required by law. Thank you, Your Honor.
Thank you. Response.
Wow. So that is some insight into what closing arguments will be if Cranick strikes down what he's trying to do here. And I don't expect that Cranick is just going to enter an acquittal right now.
Yes, thank you. Standard at this time is just a prima facie case. Whether any trier of fact, in taking all the facts in the light most favorable to the state and the inferences drawn from them, establish the elements of the crime. There are three elements to this crime. George Torres is dead has been established by a prima facie case. The death was caused by the criminal act of Sarah Boone that has been established. There was an unlawful killing of George Torres by an act imminently dangerous to another and demonstrating a depraved mind without regard for human life. An act is imminently dangerous to another and demonstrating a depraved mind if it is an act or series of acts that a person of ordinary judgment would know is reasonably certain to kill or do serious bodily injury to another. It's not Ms. Boone's subjective statements on February 25th. I had no idea you could die from being zipped into a suitcase for 13, 15 minutes before she goes to bed. 2, is done from ill will, hatred, spite, or an evil intent. We heard what she said. The 2-minute video starting at 11:12 p.m. 45 seconds would be linked in Merriam-Webster's digital dictionary for the definition of depraved mind. Fuck you. I don't care. Laughing is of such a nature that the act itself indicates an indifference to human life. Sarah, that's my name, don't wear it out. Judge, there's no question that a prima facie case has been laid. In addition to the 2-minute video and then the 22-second video 11 minutes later, we also have the defendant's inconsistent statements that she has made in regards to these events, and therefore we have that factual issue for the jury to decide.
I can't breathe. Shh. Tell me that is not evil intent. Tell me that's not depraved heart. All her statements of this is I'm getting you back. That is not evil intent? Come on.
She made statements on the 911 call and to law enforcement both on the 24th and 25th that I have no idea what happened. I just went to sleep. Everything was good. And then when confronted with her video on the 25th, we see that there are 2 distinctly different sets of statements that were made. So this is sufficient at this stage in time for a jury question. Thank you.
Thank you. Any other additional argument, Mr. Beck?
No, Your Honor.
Oh, thank you. Thank you both for your arguments. The court, in viewing the light most favorable to the state, the court finds that the state has presented competent but rebuttal evidence to establish each of the elements of the charge contained in the information to the required level of a prima facie showing. As such, the defense's motion for a judgment of acquittal is denied. Defense, do you intend on putting on a case?
Yes.
Ms. Boone, I have a couple of questions to go over with you.
Judge, if I may.
Yes, sir.
In a normal criminal trial, my position has always been to put on the defendant last, call whatever witnesses, put on exhibits, photographs, and then the client would be the last person to testify. Because of the nature of discharge and our defense, self-defense and battered spouse, we understand that we have to put on her first, Sarah first, for the court to then consider whether or not we established enough evidence for self-defense instruction. So she's going to have to be going first as the witness. I'm going to need a few moments with her based on everything that's going on and based on that denial of that motion for judgment of acquittal. To just go through it again, because I know you're going to ask to colloquy about all that. So I'm going to need a few moments with, I don't know, 10 minutes maybe for the 3 lawyers, 4 lawyers to meet with her. I don't know if we can do it here or maybe back there, but just a short meeting.
Sure, I'll give you that opportunity. But before you do that, ma'am, I don't want to go into any specifics of any conversations that you've had with any of your attorneys in this case. Mr. Owens has identified for the court his normal practice of calling a defendant last in a criminal case. In this case, he has advised that he wants to call you first. Without going into any discussions of any strategy that you've had with your attorneys, do you understand the strategy that Mr. Owens and your team will be utilizing in your defense?
Yes.
And are you in agreement with that strategy?
Yes.
All right. Counselor, you can have that opportunity to speak to her. The court will remain here. I don't know if they can, Officer Jones, can we let them back to have that conversation? Okay. All right. You can go back and have that conversation. The court will remain here. We'll be in a short recess for approximately 10 minutes. Thank you.
So the lawyers have seen it all. Sarah has seen Mr. Beck get up and make their best argument for acquittal here, and it was denied. Sarah has to go first, is not going to have the opportunity to hear everybody else's arguments, not going to have the opportunity to hear rebuttal or possible rebuttal arguments first. And now 3 lawyers and some assistants are going to sit her down and say to Sarah, are you flipping crazy? If there's a deal, lady, take it. And I think she's going to say no. I think she wants to go up there. Viv says she wants to testify as badly as they don't want her on the stand. Yeah, I think so. Mala thinks the defense made themselves look silly. I don't know. I don't think so. So I'm going to fast forward here. Jay-Z saying, I hope that deal is off the table. I'd have taken it off, but, you know, who knows? Okay, so we're caught up. Somebody said, yeah, she's going to sink herself further. Carrie says her ego won't let them not call her. I think so. Captain Katie says, of course, she's the star. Yeah. And I have to say, the defense really did, so far, vigorously defend her. They have, it appears to me, tried pretty much everything, right? And the judge did give the defense a lot of leeway, much to the chagrin of a number of viewers. He did. So you can't say she didn't get a vigorous defense. Amanda, I think she would testify today. I think they knew that, but they're going for this last ditch effort, I think. Heidi says she has to testify for all her worldwide fans. I think, excuse me, I have frogs in my throat today. I think she wants people to see her truth, her version of truth, which, by the way, she probably just made up recently. So we're going to hear a whole different thing. And I think if she tries this, honestly, I think she'd be better off with unintentional. I think she'd be better off saying, you know, I'm an idiot. I got drunk and passed out, right? And accept something smaller. That's more believable than what I think she's going to say. So she's coming back. See, there's a benefit to sometimes being behind. We can zip past those breaks. Blink Bunny says, I think she's dropping batter. Do you think? But what else? What else is she going to say? Interesting. KPM is saying that was quick. I think it seemed quick because we were behind, so I was able to fast forward through that break. So it seems quicker than it was. I've been saying from early on, battered spouse is not going to fly. Purple Haze says if she takes the stand, it will be a dismantling. I like the way you said that. Someone said she's going to take the stand and say, y'all have to know who I am. So I'm just watching her and Owens. I wish I could read lips. It probably wouldn't be appropriate anyway. Oh, Owens is hitting mute on the mic just in case. They're having a real serious discussion here. Eron is saying, chat, it's time to get your stress balls, your snacks, whatever. Prosecution's ready, man. Owens looks worried to me. What do you guys think? Really, Sarah? It'll be okay. You don't have to do this. Sarah is muting the mic. Yes, she is. Somebody has extra cheesy popcorn? I have Pop-Tarts here that I can't eat because it is way too sweet for me. Oh no, Watson thinks I have sticks. I have no sticks. Sorry, pups. I got nothing for you right now. Everybody in the chat's talking about their snacks. Oh, Frauke has toffee popcorn. I'm getting hungry. Is it like lunchtime yet? Nikki's saying this is pretty much down to the bone, nail biting stuff. Yeah. This is a crucial moment for her. I mean, she has got to be really anxious. So Cat Wrangler says, I'm eating peanuts to watch this circus. Oh, Joyce. Joyce saying, I can't have snacks. I've already washed, cleaned my teeth, and put PJs on. That's the thing. After you brush your teeth at night, that's when you get hungry, right? I noticed in Sarah's interview, they said, what do you do when you get ready for bed? She might rinse her mouth out. And I thought, ooh, like, don't you brush and floss? Purple Haze is saying, buckle up. Yep. Yeah, no smirking. Not right now. She is stressed. You can see it in her face. Cahoots is pointing out that calling George stupid and saying F you is hate. The, yeah, yeah. I think the part where he says, I can't breathe. I mean, there's a limit. You can be angry at someone and swear at them or say nasty things to them. But man, even if somebody I didn't like was in a position saying I can't breathe, I mean, I'm not going to laugh about it. You know? You try and help. What are you after? Hey, stinker. It's all gone, pups. It's all gone. So somebody's commenting about, having to watch that interrogation video in its entirety was grueling. Imagine being there. And the person's wondering, how the jury's going to respond, especially the contrast between what Sarah was like in that video and whatever she portrays on the stand. And if they end up getting into presenting former body cam video, if this self-defense can go ahead and they present that body cam video, the jury's going to see that in real life, Sarah's a completely different person than she is here. Oh, somebody counted the number of times George called her name, pleading to be let out, and it was 18 times. My gosh. We need a Watson cam. Watson moves around too much. I'd need a camera that could be robotic. Martha's asking, does the jury know she had over 8 lawyers? No. That can't be brought in. That's not relevant. Thank you, Zen Scout. Martha's saying, at this point, I think the chat could role play the entire interview. Yeah. Well, I think it's okay if Sarah and her lawyers are given the time to really thoroughly talk about this. Because we don't want her coming back saying I was rushed, I was forced, I didn't understand, right? Someone's asking, who is Sarah laughing and smiling at before a break? I don't know. After Sarah Boone's over, I'm going to have to find something else some other case to really harp on. Maybe. Somebody says we need a bingo card. Dr. Barry has a YouTube channel and she created bingo cards. So there is something similar to a bingo card specifically for this case. Oh, Al's saying Koberger. I have not dug into that at all. That would be an interesting one, I think. I've been following Corey Richens, and so I have a playlist on that. So that's going to be coming up too. Karen Reed. I think there's a retrial in January. So I'll be looking at that. I don't look at Turtle Boy's case. Somebody said Delphi, but I think that's going on now. I'd never get caught up in time. Yes, KPM, the Soto case. Yes, I am very interested in that, only because I think there is a lot within that case that would be educational for the public, particularly for parents and grandparents, warning signs, this sort of thing. But for some reason, I cannot get documents on that.
We're back on the record. Case number 2020 CF 2603, State of Florida versus Sarah Boone. State, appearances for the record.
Dave Kester on behalf of the state.
William J. for the state.
Defense?
James Owens from Ms. Boone.
Tony Henderson for Sarah Boone.
Kevin Zach on behalf of Sarah Boone.
Ms. Boone is seated at counsel's table wearing the same black blazer and dark blue blouse from this morning. She is in custody, however, not wearing any restraints, so she'll be able to stand when our jury enters, and if she is called to testify in this matter, she will be able to walk to the witness stand. Ms. Boone, I have a couple of questions to go over with you. Similarly to our conversations earlier today, I don't want to know about any of the substance of any conversations you've had with your attorneys, just whether or not you've had certain conversations. So far, you've been present throughout the entire trial process. You've been seated at counsel's table. You've had the opportunity to observe the evidence presented by the state, as well as the direct and cross-examination of the state's witnesses. Are you satisfied with your attorney up and until this point?
Yes.
Now, I'm going to ask you some questions again about specific conferences and conversations you have with your attorneys. I don't want to know those specifics, just whether or not those things have been had. Have you had the opportunity to discuss with your attorneys whether or not you would like to testify as a witness in this case?
Yes.
Do you need any additional time to discuss that matter with your attorneys?
No.
Have your attorneys discussed with you the potential benefits and potential harms of testifying as a witness in this case?
Yes.
Are you satisfied with the advice from your counsels?
Yes.
Do you understand that attorneys can make most of the decisions about trial strategy? They cannot determine whether or not a defendant testifies or not. Do you understand that?
Yes.
Not even the court can interfere with the defendant's right to make that decision. Do you understand that?
Yes.
Do you understand that it is your decision and your decision alone?
Yes.
While counsel can give you advice on whether or not it would be wise for you to testify in this case, do you understand that you can ignore counsel's advice because the final decision is yours?
Yes.
Do you understand that you have the right to remain silent?
Yes.
Did you hear me explain to the jury at the beginning of the trial how the right to remain silent is absolute, and the fact that a defendant did not testify cannot be considered as evidence of guilt or influence their verdict in any way?
Yes.
Before a jury begins its deliberations, the court will read another jury instruction if you decide not to testify. This instruction orders the jury not to consider your silence as evidence of guilt or to consider your decision at all. Would you like me to read that instruction for you at this time?
Yes.
It is instruction 3.9a, entitled Defendant Not Testifying. The Constitution requires the state to prove its accusations against the defendant. It is not necessary for the defendant to disprove anything, nor is the defendant required to prove her innocence. It is up to the state to prove the defendant's guilt by evidence. The defendant exercised a fundamental right by choosing not to be a witness in this case. You must not view this as an admission of guilt or be influenced in any way by her decision. No juror should ever be concerned that a defendant did or did not take the witness stand to give testimony in the case. Do you have any questions about this instruction?
No, Your Honor.
Do you understand that if you choose to testify, you are waiving your right to remain silent?
Yes.
That means once you begin to answer questions, you have to answer all questions unless I instruct you not to answer a question. Do you understand that?
Yes.
You cannot pick and choose which questions you want to answer and not answer. Do you understand that?
Yes.
Do you understand that if you refuse to answer any questions, the court can impose sanctions, such as holding you in contempt, striking your entire testimony, and instructing the jury not to consider any of your testimony? Do you understand that?
Yes.
If you choose to testify, you will also be subject to cross-examination and impeachments for crimes of dishonesty if you have any such convictions. If you have any such convictions, the questions will be limited to whether you have such convictions and the number of same. Do you understand that?
Yes.
Are you aware if you have any such convictions?
Yes.
State? Are you aware of any felony convictions or convictions for crimes of dishonesty?
No, I believe she's answering an affirmative. She's aware that she doesn't.
Okay, so you have no such convictions. Okay, thank you for that clarifications, ma'am. As there are no convictions, and that number is not in dispute, the state will not be permitted to inquire into those matters. Have you had enough time to discuss your decision to testify or not testify with your attorneys?
Yes.
Again, do you need any additional time?
No.
Has anyone forced you, threatened you to get you to testify or not testify in this case?
No.
Has anyone made any promises to you to get you to testify or not testify in this case?
No.
Are you satisfied with your counsel's advice so far in this case?
Yes.
Are you making this decision freely and voluntarily?
I am.
Did anyone force you, threaten you, or coerce you to testify in this case?
No.
Would you like to testify or not testify as a witness in this case?
Testify.
Okay. And ma'am, similarly, after you've had the opportunity to converse with your lawyers again, I want to confirm that you're on board with the strategy that they've utilized in your defense in this case,
Yes, I understand.
including calling you first.
Yes.
Okay. All right. I want to remind you, ma'am, that you can change your mind. You just have to let your lawyers know before the jury comes back in. Do you understand?
Yes.
State, anything else we need to address?
Just that the law of the case is that there should be testimony from the defendant of an overt act that particular day before there is testimony about reputation evidence, prior instances of violence, or any of the ancillary things that come in self-defense.
Holland case speaks for itself. Anything further?
I do want to talk about that, but as it relates to her right to remain silent or testify, I have nothing about that.
Okay. Then what do we need to address with regard to Holland?
Well, I've got three issues. One is Holland. The other is I've got these gloves. My client and I would like to take a few moments to look at the suitcase and to look at that. And then the third thing is that the state had filed that motion for the in-camera hearing. I don't know. Maybe we need to hear that before she testifies.
Court's not going to address that at this time.
Okay.
We'll address that later in the proceedings.
So the two things, number one, of course, I've got a lot of photographs about the prior violence that George Torres committed on Sarah Boone, and there is a dispute about whether or not I have to establish an overt act that she responded to.
There is no dispute about whether you have to establish an overt act. I'm sorry if it's loud, I'm yelling. This was argued before. Why are you bringing it up again? Why? So you want to introduce all this reputation evidence, all this, throwing mud at Mr. Torres without actually establishing the overt act. What's the matter, Owens? Are you scared? Because your client is going to lie her face off and might not say the right lies. Oh, that's irritating.
That she considered an imminent threat and that she took evidence or she took action to either block or physically restrain George Torres from committing an act of violence on her. But Judge, if you'll remember, during the 2-hour interrogation, the officers make mention that they are aware of the prior incidences of violence. So I believe the door has been open, that I can go into that based on those statements by the two detectives. If you remember, they introduced this 2-hour video. She says, he comes at me all the time. I think eventually Sarah Boone realized that they had her phone and they were going to see pictures, they were going to see videotapes of evidence that George Torres committed acts of violence on Sarah Boone. I think at that point she changed her tone about George. She was trying to protect George, but then she realized she would have to disclose.
Oh, yeah. So I knew they were going to use that. They're going to try and get it in a different way, claiming the state opened the door. Wow.
Some of the acts that had been committed on her by George Torres, and so she did talk about him coming at me, and we've had issues before, and the officers gave, I can't remember exactly what they said, but yeah, we're well aware of, I don't know if they said the prior acts or we're aware of the domestic violence, whatever the case may be. I submit that opens the door. That was during their case in chief. They chose to play that entire video. And so I think I can talk about the prior bad acts before the event in question chronologically. And I've got a bunch of photographs that go into physical evidence of her injuries as a result of George's violence.
Okay. Response, if any.
Judge, we're asking for the court to maintain its ruling. We already read an instruction that the police are allowed to tell her things to try and get reactions from her. She affirmatively denied there was an overt act that night to the police. And the court, in its ruling pre-trial, as we're trying to get some guidance on this, reviewed Ms. Boone's most recent statements on the matter, and there is no overt act. Thus testified.
I see in the comments somebody is saying that the defense opened the door. No, the defense is arguing that the state opened the door. What they want to do, the defense wants to get in the prior bad acts of Mr. Torres. They want to get that in. And if they can claim that it was the state who opened the door and therefore they can get it in, then they don't have to make her testify, right? If they can weasel around that, they'll try. So, because Owens smartly wants Boone to testify last so that she gets to see everything before she gets up to tell her story, right? So if he can get in these prior bad acts of Mr. Torres and keep going with the trial and let Sarah see the back and forth before she testifies, that is better for the defense. It makes it a lot easier for him. It makes it easier for Sarah to lie. But as it sits right now, he's not allowed to do that until Sarah testifies to an overt act. And this is why the state has been very careful about not opening the door.
Testified to, so we are hopeful that we will maintain that ruling, and I don't know how it prejudices her or her team in any way to establish an overt act on February 23rd, 2020 before we go into reputation evidence, prior instances of violence, or matters of house income evidence.
Any other further argument, Mr. Owens?
No.
All right. I don't find that the officer's statements are character evidence, and you're looking for specific instances of conduct, which are going to be utilized for those specific purposes for reputation or violence to establish the fear component that the case law speaks about. Florida Supreme Court decision in Holland is clear that that overt act needs to be established before any of that evidence is submitted. I don't find that it's an opening of the door, and I'm going to rely on what the Florida Supreme Court has told us to do.
Judge, I've got to get the clerk to mark some photographs, and then my client and I need to take that suitcase out of that box and inspect it, play with the zipper a little bit, and then also take that bat out of that paper bag and inspect it before she testifies.
Any response?
I'm just confused why we haven't utilized the nearly half an hour or more that the court has been off the bench to get these photographs marked. The defense team has been on board for quite some time. They did not request a second evidence view of the physical evidence that Ms. Boone already had an opportunity to do while she was pro se. It's 11:25. We need to try the case.
Judge, I think that she had that evidence view, I think, with Billy Lane. I believe that was the day after I filed my notice of appearance, or maybe it was the day I filed my notice of appearance. I don't remember exactly, but it had already been previously scheduled. I was in Milton, so they went ahead and did it that morning, I believe at the jail. I believe the evidence...
Any particular reason why it hasn't been done in the last 45 minutes?
Because
when I sent my jury out?
I've been meeting with my client about her rights to testify or not, and other related matters. So in terms of not giving her this evidence?
In terms of anything that the state just discussed?
I've just been busy with my client.
Okay. How much time do you need in order to pre-mark these exhibits and look at the baseball bat and the suitcase which have been entered into evidence?
I would think 15 minutes.
I'm very concerned because it is 11:25.
Don't know what's going on here.
Early lunch. It's 11:30. Let's take an early lunch. We've got witnesses coming this afternoon anyway. If her testimony ends before 5, we've got 1 or 2 witnesses that are here, and then I believe tomorrow is Wednesday. We've got Dr. Brannon that's going to be here first thing Wednesday morning, and then I believe Dr. Harper's not going to be here till Thursday morning. So we're going to have a little...
He's stalling. I think Owens, I think the defense team is nervous. Sarah isn't where they need her to be on this. And it bothers me that they are going to look at the suitcase again. The reason it bothers me is not because she doesn't have a right to. She can examine the evidence, but I so don't trust her. I think that's why it's getting me.
Gap in time, unless we've got to put on several officers about prior acts and all that. But I think for purposes of this, Judge, in the abundance of caution, I feel like I need to go over this evidence with my client before she testifies. And I have not had a chance to view that evidence other than seeing it here today. But I think I need to do that with her before she testifies.
Okay, can the parties approach for a moment?
I'm loving the looks that Kranick is giving him. I'm going to fast forward past the approach if I can. Oh, we're seeing the view of the gallery. We haven't seen that yet. Yes, I've been busy with my client because she's flipping high maintenance. J Soul says, I think he wants to end the day with the end of his direct of Sarah. Interesting. He did state on the record he planned on having her up at 10 a.m. I don't know if I'd want to, if I was him, if I'd want to end on that note. I might want to end on a police officer or something else. So Neil is asking about people in the gallery. I don't know who anybody is. Except for Billy Lane, who I recognize sitting back there. Al says Owens is playing the Lionel Hutz stereotype to a T today. That's funny. Lizzie says, I was dying for someone to mention she'd had evidence for 4+ years. Oh, Linda's saying, don't think the judge isn't catching Sarah's smirks and smiles. She really thinks she's going home. Loba says, justice has to be about facts, not games. They accept it's in a lot of ways a big game. I'm not saying that it's not a serious, solemn game with tremendous consequences, but there is a dance, right? Back and forth. Somebody's saying it's interesting to watch how it seems the attorneys are pretty nervous about putting her on the stand, yet she seems not too bad. You know, she wants to go up there. Someone's commenting, Sarah's taken advantage of everything. Yeah. Ellie is saying, I'm back. I'm guessing the acquittal was not granted. Nope, it was not. Oh, somebody's commenting a doctored pepper. Interesting. That's funny. Elle is pointing out, just like a trigger warning for everybody, that Sarah's probably going to say a lot of infuriating things. I suspect that's true. I suspect she's going to, well, what I suspect. I am confident she is going to lie. And I am probably going to get irritated, and so are you. So self-care is important, but we can all be irritated together and say, what? Together? We can poke fun at things together. And hopefully that helps a little bit. And make sure, you know, everybody engages in self-care at the end of the day today. Somebody saying she's going to look worse than Alex Murdaugh. Yeah. Melly, prosecutors can object during narrative testimony if they have the grounds to object.
It is 11:35. Councils have matters that they need to address with Madam Clerk for the pre-marking of exhibits, along with the review of the suitcase and bat, which were previously entered into evidence. I'm going to bring based on the agreement of the parties, I'm going to bring our jury panel in at this time, release them for lunch, give them a similar instruction to the instructions they've been provided earlier, and we will commence promptly at 1 o'clock this afternoon. State, any disagreement with the battle plan so far?
No, sir.
Same question, Mr. Owens.
No, sir.
All right, let's go ahead and stand back. Bring it back in our panel. Back in our panel.
like we'll have an early lunch today.
Jury entering.
I hope that plea is still not on the table.
State, do you recognize our jury?
Yes, sir.
Defense, do you recognize our jury?
Yes.
I thank you all can be seated. Members of the jury, again, once you're seated and comfortable, if you could raise your hands to confirm that you complied with the court's instructions. All right, thank you very much. Thank you for your patience. Matters with counsel took a little bit longer than we anticipated. We're going to take an earlier break today. It's 11:35. We anticipate the defense putting on a case this afternoon, and we don't want to get into it and then have to break a half an hour into it. So we're going to go ahead and take that break at this time. I'm going to give you a similar instruction as I've read to you over the last couple of days. Jurors, you must not conduct any investigation on your own. This includes reading newspapers, watching television, or using a computer, cell phone, the internet, any electronic device, or any other means at all to get information related to this case or the people and places involved in this case. This applies whether you are in the courthouse, at home, or anywhere else. You must not visit places mentioned in the trial or use the internet to look at maps or pictures to see any place discussed during the trial. Jurors, do not watch local news or read local newspapers. Jurors must not have any discussions of any sort with friends, family members, or even your fellow jurors about the case or the people and places involved. So do not let anyone make comments to you or ask questions about the trial. I want to stress again that just as you must not talk about this case face to face, you must not talk about this case by using an electronic device. You must not use phones, computers, or other electronic devices to communicate. Do not send or accept any messages related to this case or your jury service. Do not discuss this case or ask for advice by any means at all, including posting information on an internet website, chat room, or blog. With that, members of the jury, I thank you for your time and your service and your attentiveness, and we'll see you at 1 o'clock this afternoon. Thank you.
Okay. I am going to check the chat a little bit and talk, but if you're somebody who's wanting to leave now, by my watch, it is 11:41 a.m. their time. They are coming back at 1 p.m. So that's an hour and 19 minutes. So if you want to leave and come back to the new stream after lunch, for those of you who want to chat, I'm going to just have a look at the chat. Captain Katie is pointing out that this month is Domestic Violence Awareness Month. I think every month should be that month. And I just want to check and make sure nothing else happened here. Oh, hang on.
Y'all may be seated. Thank you. State and the defense, if you could please review those items and please mark every defense exhibit at this time with Madam Clerk, and I will see you all to commence promptly at 1 p.m. Court's in recess. Thank you.
Okay, I'm going to switch screens here so I can see you guys better. Here we go. Someone's going to the store for Pop-Tarts right now. Yeah. So what do you think her plan is with the suitcase? Somebody's asking that. I am interested in hearing what everybody in the chat thinks is Sarah's plan with the suitcase. Romeo Saints is saying something tells me that Sarah will do an example of going in and out of the suitcase. My goodness. If somebody I loved passed away I wouldn't want to be in, like, I wouldn't want to get in there. That would be horrifying. So I don't know if she's wants to look at it really closely, in order to come up with some other excuse or some way that he could have escaped, or, something to help her story along. I don't know that they're going to zip her into the suitcase. Yes, Vicky is saying that you think that she's going to use the suitcase to show how she poked George's fingers back and with the baseball bat because he was going to come out and get her. But, then she claims that she left room for him to get out. So, I don't know. If that's the overt act, that's something. And those injuries to Mr. Torres weren't from her poking him with the bat. She would have had to really hit him with that for some of those deep tissue injuries to occur. So KPM is suggesting Sarah wants to show that the zipper glides easily. Well, the zipper could be a state-of-the-art zipper. It could be top of the line, smooth glide, Samsonite zipper. But if you're in the fetal position and crunched up like that, how do you maneuver to open a zipper? And I don't know how he would have to be situated in there for him to be able to open the zipper and also, yeah, I don't know. I don't know how you do that. I don't know how you do that in that position, in that small of a space. Nick V says they want to examine the zipper in order to come up with a better explanation. I agree. I agree. I think Sarah and the bat, she wants to look at it very closely. It's not like she's not familiar with the bat. It was in her house. It belonged to her son. It's not like she's not familiar with it. So I think, so Jessica's saying Sarah's going to focus on providing her baby talk damsel in distress. I'm always the victim. Yeah. So I think I'm going, Neil is saying this is all likely nonsense by Owens to prove some disagreement he is having with Sarah. That is possible. It's possible that they're still trying to say to her, listen, you're going down if you do it the way you want to do it. But, Sarah's got a Sarah. So I am going to end the chat. So I will see everybody at 1 o'clock Florida time. So that is an hour and 10 minutes from now. I am probably going to start the chat, a couple of minutes early, just so I can say hi to everybody and make sure that my stream and everything is working properly. Thank you all for being here. This is the best chat. You guys are hilarious and smart. You're terrific. And I will see you at 1 o'clock. Thanks for coming. Trust your gut.